So hi everyone, we have assembled here to talk a little bit about the South China Sea. That is Nathan George, and Nathan George is a PhD student here at the School of Law of Murdoch University who will actually write in his PhD about many things, but at the core of everything that he will write about is the islands. And because islands are at the core of the South China Sea dispute with China, we thought we could have a little podcast here and talk about some international law ramifications of the South China Sea problem. Nathan, tell us a little bit about your PhD project before we get into, and a little bit about yourself before we get into the South China Sea.
Sure. I had a particular interest in my master's study in international law of the sea matters, and I was very interested in islands and their status under the United Nations Convention on the Law of the Sea, UNCLoS, and in particular the South China Sea, East China Sea islands, and also some islands off Japan. And from that, my interest has grown into a PhD proposal now, and what I hope to be researching at Murdoch in my future PhD endeavours about South China Sea and other related islands around the world.
So tell us a little bit about yourself. What brought you into this subject and into being particularly interested in islands?
I think it's their unique status in international law. We've got UNCLoS that talks about what islands are and what rocks are, but before we had a particular ruling a few years ago, that area was very much a grey area. So we had some academic talk about what this might be or what that might be, but there was no definitive international adjudication about exactly what the status and classification of rocks and islands are.
And you have already given it some thought in a previous master's thesis, haven't you?
That's correct, yes. I did look at some islands and rocks in the South China Sea and other areas, and I identified, this was before this decision, I was talking about what some of the issues might be. But since my my master's paper, we've had this decision that's come out from the Permanent Court of Arbitration in The Hague that has clarified what those issues are. And now we're looking at new classifications on existing features that might have been incorrectly classified by the states that claim them as their territory. So that's this new branch of evolving law that's coming out at the moment in international law of the sea matters.
So you've mentioned now in your conversation several times that decision, decision by the Permanent Court of Arbitration in The Hague concerning the Chinese claims to maritime rights, very neutrally formulated in the South China Sea. We've seen this in the news. The countries that have an interest there or an interest in what the outcome and the legal outcome of this dispute will be, are conducting freedom of navigation exercises, which then make it to the 8 o'clock news every time that happens. So we're segueing into the topic of this actual podcast, the South China Sea, and maybe we should start at the outset by very generally explaining a little bit what the relevance of these islands could be in terms of the law of the sea and in terms of the territorial implications that has for those directly involved, but also for the broader world community.
Sure. Of the South China Sea, located between, say, 5 different states, it's a massive area, 3.5 million square kilometres. We have 1/3 of the maritime global trade going through that area. So we're talking a significant amount of commercial shipping. We have a lot of strategic activities in those areas as well. And like I said, because you've got these countries surrounding this particular sea, each have their own take or stake in the islands and other features that they claim to be theirs, which of course they then can strategise about their military activities or customs activities or even fishing activities. So geographically, geopolitically, these features are central to the claims, and I guess the ownership of some of these features around can generate claims regarding, one thing that's come up is the air defence identification zones in these areas where a country will basically say to an incoming state vessel or aircraft that you must identify yourself and state your business before you transit our airspace or our waters. So we're looking at some big issues about control and about access to the waters in this very, very trade-intensive area of the world.
Of course, there's also very hardcore economic interests.
Absolutely.
We know from, if we leave the South China Sea just for a moment, under general public international law, coastal states have a decreasing area of sovereignty into the sea. I think the first delineation would be what is called the territorial waters, the so-called baseline, which very roughly speaking is the lowest point the water will reach at any given point.
Yes.
And everything that's within that is treated as if it were land.
Yes.
100% sovereignty of the state. No other state has any rights within that baseline, within those territorial waters.
Sure.
And then we have the next step beyond that, which is commonly referred to as the
contiguous zone.
Contiguous zone, which is 12 miles.
Yes, 12 miles.
It used to be historically the good old 3-mile zone with the cannon reach, but it's now 12 miles. That is an outcome of decade-long negotiations in the United Nations Convention on the Law of the Seas.
That's right. Yes.
Within that 12-mile zone, the coastal state retains almost all of its sovereignty, but not all of it.
That's correct. It's what's happened is pre-UNCLoS, there was a lot of uncertainty about the boundaries, who can fish where, transiting ships, what happens where. So we start with I guess the basis that the land dominates the sea. That's the basis of where we're talking about jurisdiction in water from the land. And from there we go back to the old 3-mile cannon shot rule in history. And of course advances in technology and shipping meant that these zones have to be moved out. So over a course of many years, and especially around the World War II time frame and after that, and leading into the Cold War, we had states looking to constantly expand their zones. And of course the other area that came up was resources. Technology has really focused on where and how far we can go out from our land areas and explore the ocean floor and what's under the ocean floor.
Right. So currently, generally speaking, not South China Sea specific, the broadest extension of these lines into the sea is the exclusive economic zone.
Yes.
Which is the old 200, or not the new 200, the old continental shelf.
Yes.
The new 200-mile zone.
Sure.
Because some countries, especially South American countries, Chile, don't have a continental shelf.
No.
It's very common geographic or geological, I'd rather say, feature, but not all countries have it. So that has evolved into the general 200-mile zone, whether there is a continental shelf or whether there isn't.
That's correct, yes.
And the importance of that 200-mile zone is that whereas the sovereignty rights of the coastal state are limited, the one thing remaining there is the exclusive rights to any and all resources there, living and underneath the ground, so oil, gas, anything else that you can dig up, and the fish in there. So we're looking economically at a very important area, the 200-mile zone. So if we transfer that back into the South China Sea, and the claim that the People's Republic of China is laying to that area, we have a number of different features. One of them are the islands that they claim are sitting there and in essence belong to China. And the immediate consequence of that, if that were true, was that around each of them, you would be able to draw a 200-mile zone for exclusive economic rights.
That's correct, yes.
But that's not all of what the Chinese are asking there, is it?
No, and that's a valid point, because if you were, in theory, to take each of those geographical maritime features, and I'll call them that because what
we'll
their
get to
status
that.
is coming up.
Yeah, we'll get to that.
So we'll come to that. So if we take these features and for argument's sake we endow them with the full ambit of UNCLoS maritime zones, so we're talking territorial sea, contiguous zone, exclusive economic zone and continental shelf. So this creates vast pockets of ocean space that China would claim to be theirs, but if you look at that or superimpose that on the 9-dash line map, that doesn't match. So there's a non-match between what China would say was its historic rights in 9-dash line versus...
The 9-dash line is a term that goes back historically to a map that on which, in essence, China, that's the main piece of evidence historically that China claims, on the basis of which China claims that this is somehow theirs, and we leave that open what theirs might mean.
Sure.
And it is a line that has 9 dashes at the bottom of the South China Sea, and in essence everything that's within or north, if you want to look at it that way, towards China, belongs to China. And it's a historical map, I think, from the mid-1800s. That is the core base of evidence brought forward by China.
Sure.
Now, within that are a number of islands, and the arbitration judgment decision that we are talking about was specifically an arbitration between the Philippines and China, and specifically concerned a number of, we shouldn't call them islands, we should call them maritime features, that are commonly known as the Spratly Islands.
Correct.
They are known as the Spratly Islands. They are not known as the Spratly Maritime Features.
No, they're not. No.
And legally, if they were islands, if they were legally islands, then we would have a situation that you could draw, as I've explained earlier, the 200 miles around.
Correct.
What was the decision that the Permanent Court of Arbitration in The Hague came to in these proceedings?
Sure. Specifically, the Philippines asked the tribunal to examine 8 islands or maritime features
from that Spratly layout,
from that chain of islands, from that grouping, and of course I should say at the outset there are hundreds of maritime features in the South China Sea, hundreds. So we're isolating a small group for the purpose of examination now. So we take the 8 features, and basically it's Article 121 of the UNCLoS,
United Nations Convention on the Law of the Seas.
And based around the tribunal's assessment and classification with Article 121, the tribunal determined that none of those features are islands. Legally, none of them are islands. Therefore, they don't... And
why are they? Why did they say that?
Okay, so an island is a naturally area of land, naturally formed piece of land, surrounded by water, and apparent at high tide. So it is constantly above the waterline. So that's what UNCLoS says an island is. A rock, however, is a feature that cannot sustain a human habitation of its own or an economic life of its own. So rocks and islands are separate entities under UNCLoS, and therefore rocks cannot or do not have the prescribed zones that islands do. So a rock will have a 12 nautical mile territorial sea, but not the exclusive economic zone or the continental shelf. So there's a big difference. There's a big band of what a rock is, or what a rock can
In other words, legally it is absolutely important whether I can qualify something as an island in the legal sense.
Correct, yes.
Or whether we have a maritime feature that is always visible above water, but which mightn't be an island in the legal sense.
Correct,
and that is what you have referred to as a rock, for example, but it doesn't necessarily have to be a rock. It could be anything that sticks up above the water, but is unable to sustain life in that sense. What would be criteria that would allow us to say it sustains life in the sense that we could really seriously start thinking about qualifying as an island in the legal sense?
Sure. That's a good question, because we're looking about whether the feature has potable water, drinking water, whether there might be shelter on the island, what sort of constructive activity, economic activity can generate on that island and sustain the population commercially, trade. So there are a number of things that the tribunal looked at, these features, and whether they could sustain human life or have an economic life of their own. So where you have features that are currently held by, say, a garrison, the Philippines have run aground a navy boat on a reef near an island, or what would be a rock, and have stationed a garrison of troops on there and resupply them with food and materials and water by airdrop. So what we'd say there is that feature, is it above water at high tide? We don't know. Can it sustain human habitation or life of its own, like for people or for economics? We'd say no, because the Philippines has to regularly fly out provisions to these garrison troops on this particular feature. So if we're having a situation where a feature, where people on a feature can't live without this constant flow, regular flow of food, water, materials, building materials, whatever it might be, fuel for running generators, we would say that couldn't be an island. It would have to be a rock.
Right, but we would, of course, look at this a bit more, how should I say, practically. We wouldn't say, if you and I were placed on that island and we'd starve to death, that alone would mean it couldn't be an island, because we might just not be inept enough or to grow something quick enough. But
sure.
It's a bit of a look at the feature, and if it could, there is a well, and if you did have the time, you could grow something.
Yes.
And the fact that you would be supplied with books and other stuff that you can't make yourself, that wouldn't take anything away from it being an island.
No.
Conversely, what about these features that the Chinese are adding? I mean, we're seeing that in the media,
Sure.
building landing strips,
Yes.
making the feature bigger and more permanent, or whatever you want to
Sure.
call it. What about that activity
So
legally?
Sure, and that's a good question, because these transform features. So for argument's sake, we have a reef that's below water at high tide, but drying in low tide. So we have a reef. So what China has done is conducted a massive land reclamation activity, thousands and thousands of tons of sand and coral and all sorts of things from the nearby ocean floor, pile them onto these features so that they're permanently above water at high tide, and then built structures, so lighthouses, buildings, observatories, weather stations, all sorts of the infrastructure on these islands, or new man-made islands. But what the Court of Arbitration said was, no, we have to look at the feature in its original status before human intervention. So what we say, and what the Permanent Court of Arbitration said, was that we will not look at these features as they've been formed by man-made, like reclamation activities. We'll only look at them in their natural position, their natural setting. So if you look at the award, they have these photos. They've generated photos of these features before human activity, and then after the massive island building activities that China's undertaken. And to be fair, there are other states in this region who have also participated in island building of various degrees. But the standout feature is China has done it in a massive scale and in a very short time frame that pales into comparison that any other state has done prior to this.
So legally, there are actually two issues in there. The one question is it actually legal under international law that they add these features? It could only be if the rock belonged to China.
So we're looking at ownership.
So that ownership,
sovereignty,
is it a Philippine island,
Yes,
or
that's
a rock,
correct.
a Philippine maritime feature,
Yes.
or a Chinese maritime feature? That
Yes.
would determine the question: can I actually build on there?
That's right, yes.
And the second question, which is somehow independent of that, but of course linked, is what is the legal consequences of building, extending that formation? And the answer that the Permanent Court of Arbitration has given us is there are no consequences.
No.
It was a non-island maritime feature before.
Yes.
It will remain so after the construction, and therefore no legal consequences will flow from that. And in essence, then the question then is reduced to, well, was I actually allowed to build on there, or was that Philippine feature, and only they could build on that.
Yes.
Okay, I think that decision is a very long decision.
Yes.
I think for this particular podcast, I think we've given an overview.
Sure.
I think there might be space for us to come back and do a part 2 and
Yes.
go into maybe some of the more detailed questions. But I think as a first overview in how this links to general public international law and delineation questions in the CE, I think this was quite helpful. So thank you very much.
Thank you.
And I think we might be back.
Absolutely. Look forward to it.